Thank you, Hank, for that very warm introduction. And there's backstories to all of that, of course, but I have a very wide and varied career and path that led me to where I am today. So pleased to be here to talk with you all. It is great to get a chance to talk about the basics of estate planning and probate. And so my first question, because I am a law professor and I like things to be interactive, is how many of you have a will? Don't be shy, raise your hand, and it's okay if you don't, because this is kind of the same thing when I ask my students in my class, although they, most of them are like, what? We're like law students, why would we have a will? So we'll talk about why you should have a will, and even if you already have a will, why it's a good idea to periodically review that will and make sure it is up to date and it currently reflects what you want to have happen in the event of your death. So we're gonna go through, first of all, the basics of what happens if you don't have a will, what happens with intestacy. We'll talk a little bit about wills, what they do, and how you would make one. Talk about non-probate property, because a lot of you probably have assets that will never actually pass through probate estate, through probate administration. They are what we call non-probate assets. They pass by beneficiary designation, for example. So how many of you have life insurance or a retirement plan? Right? Beneficiary designations on those. So a lot of assets pass by not through probate, and you need to make sure those beneficiary designations are up to date. And finally, one of the things Hank didn't mention, but one of my passions and one of the things I practice and I've taught is nonprofit law. So I would be remiss if I didn't also talk about how to incorporate your philanthropic goals into your estate plan. So we'll finish at the end just to talk a little bit about some things, if you're philanthropically minded, that you might be able to do. So that's kind of where we're headed today. Let me go next to my standard disclaimer. We can't be lawyers without providing legal disclaimers, of course, but I do want you to know that even though I am still currently licensed, I don't actually practice estate planning anymore. I am full-time professor. I'm also the Associate Dean of Academic Affairs at the law school, and that is the equivalent of like 3 jobs, so it keeps me plenty busy, so I am not taking clients or drafting wills. So the good news for you, of course, is that means I'm just here to be honest with you about what the law is and what goes on, right? However, this is really just a general information session. I'm not here to provide individual legal advice, and I strongly encourage folks who need help with their estate plan to find a qualified attorney to do so, and we can give you, point you in the direction of some resources that you can look for if you need to find an attorney. So that's my disclaimer. Let's get started on the intestacy. Okay, so in order to understand intestacy, you also have to understand the basics of community property law here in Texas, because if you're married, you can have community property or separate property. And those of you who are married, hopefully you're well aware of what these requirements are, but just in case, I'll just review it for everybody. So separate property, that's probably the easiest thing to start with. It's typically the property that you own before you get married, or property that you acquire during marriage by gift or by devise, meaning someone else's will, or inheritance. So basically property you acquire at someone else's death, or property you acquire by gift during your marriage, that's your separate property, as well as property you own before marriage. And you can kind of trace that through different forms while you're married and buy new things with it and all of that good stuff and still retain that separate property character. Community property generally is everything else, including income earned off of separate property. So examples would include your personal earnings, interest and dividends on separate property stocks, for example. All of that is community property. And the key thing is when the marriage dissolves, and in our instance, we're going to talk about the marriage dissolving by death. When the marriage dissolves, all of the property owned by the decedent is presumptively community property. Okay, that means we're going to assume it's all community property unless someone comes in and shows us that it is separate property. So it's important to keep good records to establish the separate property nature if you do have separate property. Why does all of this matter? Because it gets complicated in Texas. When you die without a will, or if you die, I should say more technically, without a valid will, so we have to have a valid will in Texas, or if your will does not fully dispose of your assets, and that can happen sometimes. For example, if you have a gift in your will that has lapsed, it fails because the beneficiary has predeceased you, then perhaps your will doesn't fully dispose of all the assets you own at death. And so any assets that are not disposed of by your will are going to pass by intestacy as well. So important to understand the intestacy rules. And our intestacy rules in Texas depend, if you're married, on whether it is community property or separate property. So that's why it gets a little bit complicated. So for community property, and this is when my students start crossing their eyes because we start going through all these rules, and trust me, after like 2 or 3 weeks, they get it. So, and we have about, 40 minutes, yeah. You guys will get it. You'll pick it up much faster than them. For community property, it depends on whether you are survived by descendants, children, grandchildren, who are also the descendants of your spouse. Okay? So if all of your kids and grandkids are also the children, grandchildren of your surviving spouse, then your spouse takes all of the community property. Likewise, if you have no surviving descendants, then your spouse will take all of the community property. But if any one of your children, and this is really important with blended families, right? It's very common. If any one of your children is not also the child of your surviving spouse, then your half, the decedent's half of the community property, will go to the children and their descendants. So go to children and grandchildren instead of to your surviving spouse. That may not be what you want. Right? So really important to understand how the intestacy laws would work in Texas, because if that's not what you want to have happen with your property, then you have to write a will to do a different disposition. With separate property, now this is where the I's really cross. It gets much more complicated, okay? And not necessarily in terms of the ifs, because it always goes the same. It doesn't matter if the kids of the marriage, if the decedent's kids are also the kids of the surviving spouse. That is not what we ask for in separate property. We ask for whether or not it's real property, like your home or a ranch or oil and gas interests, or if it's personal property, which is essentially everything that's not land. Okay, so if it is separate personal property, I'll go through that first. Your surviving spouse will take a third of it, so stocks and bonds, things like that. If that's separate property, your surviving spouse gets a third, and your kids get the other 2/3. Again, may not be the disposition that you would want with your separate property. For real property, this gets super complicated. Your surviving spouse will get a life estate and a third of the property, meaning they have the right to live there. Okay. And your kids get the rest of the interests, okay? So basically it's going to eventually go to the kids, but your spouse will have a right to live and use that property while she is alive because she gets that 1/3 life estate. So it is really complicated. I've had, back when I was practicing, I had a client whose, it was a consult from a New Mexico attorney because his client who had died, and she lived in New Mexico primarily, but had a ranch here in Texas, which of course was her separate property. And when I tried to explain this rule to him, he thought I was joking. He's like, come on, like tell me what the real rule is, right? I'm like, no, like this is really how Texas intestacy law works. And he's like, that is just so complicated, right? Because he's trying to work out a settlement with the family and trying to value exactly what that is was a little bit complicated. So again, this is why wills are really important, especially I think with separate property, because this is probably not what most people would choose by design to have happen with their separate property, where they would probably pick different dispositions. So a will is a great way for you to express what you want to have happen. If you have no children, then and you're married, then it gets a little bit easier with the separate property. Your surviving spouse will take all of your personal property, all right, stocks, bonds, bank accounts, all of that good stuff. And then the separate real property, the land, goes half to your spouse, and the other half will go to your parents and siblings and their descendants, nieces and nephews, again, if you don't have a valid will. And then for folks who are not married at the time of their death, I've given you a little chart. You can read through that and kind of see which situation would apply to you. But usually what happens if somebody is not married at the time of their death, it's first going to go to their children and grandchildren. If they don't have any surviving children or grandchildren, then to their parents and siblings, nieces and nephews. And then we just kind of keep going farther and farther out on the family tree until we find someone who can take. If for some reason the individual has no blood relatives, then the property will go to the state of Texas. And so that's really important for people who may have a really great relationship with their in-laws or their stepchildren and their spouse has predeceased them. The Texas intestacy law will not give property to your stepchildren or your in-laws. So if you continue to have those great relationships, even after your spouse's death, you have to write a will to leave property to stepchildren and in-laws. The state intestacy laws will not do that for you. Question, yes?
So when you say blood relatives, does that apply to the other parts of it? Like what if someone's adopted?
So adoption is the equivalent of blood relatives in Texas. So if somebody is adopted into the family, we treat them just like a blood relative for intestate distribution purposes. Yeah, great question. And I will save some time at the end, I promise, for questions. So feel free to write questions down as we're going along, and I'm more than happy to answer any questions you have at the end as well. Okay, so that brings us then to, let's talk about wills, right? So we talked about intestacy. This is what's going to happen. And basically, the intestacy is the state's writing your will for you, right? That's what's going to happen if you don't have a will. But it's a really great idea to think about doing a will if you don't have one already. Or again, if you have one currently, please review it, make sure it's up to date and it's what you want. First reason to have a will, it can express your desired distribution of property. Right? So who do you want to have take it? And you can express things like, well, okay, if my child doesn't survive me, then I want that person's share to go to this person instead, right? You can express those conditions and who's going to take in the event someone else doesn't survive you, all of that good stuff. You also get to designate the executor or personal representative of your estate. So this is the person who would manage your estate administration after your death, and you can choose who that is. And again, choose in order of priority, right? And you know your kids, right? You've got the one kid who would be really great at this and really responsible. And yes, you love all your children equally. I have 4, trust me. They all have very different personalities and strengths, okay? Even at young ages, I can see this, right? So you know this about your loved ones, and so pick the ones who would do a really good job managing, right? This is not about favoritism or having a place of honor or anything like that. This is really about managing financial assets. So pick somebody who's good at that, and maybe it's not any one of your loved ones, right? And then you want to start looking at maybe other options for picking an executor, but you get to pick, right? If you have a will, you get to make that designation. You can also provide for what's called an independent administration. We'll talk about that briefly when I talk about probate administration, but just know for right now, it is a way to basically minimize court involvement in your probate estate. And so it's a really great tool. Highly recommend it for folks to think about independent administration. And probably most importantly, this is a way for you to create a trust if you need one to take care of certain beneficiaries. So an example in my life is all my kids are minors. My oldest is about to be 17. And if something should happen to me and my husband, right, we don't want to just hand them a big wad of money. First of all, they can't even legally do that right now. They can't manage their own money. But even if they could, right, my 17-year-old would probably go right out and buy a car, followed quickly by his next 2 brothers who are 15 and about to be 14 respectively, and Teslas are high on their list. Not a bad investment, of course, but I'd prefer that they use that money for college. So this is where I can make those directions, right? And also, I don't want to necessarily have to have a guardian for a minor child's estate, right? That can be pretty expensive and costly. So you can create a trust that can hold the money for if the beneficiaries of your estate might be minor children, such as children or grandchildren, so that can manage that property for them until you decide how old they should be to get it. And again, with a guardianship for a minor child, they will get the money at 18. I remember how I was at 18. Y'all can think back to how you were at 18 and think about what if you got $100,000, right? What would you have done with it, your 18-year-old self versus perhaps your 25-year-old self or even your 30-year-old self, right? So if you create a trust, you get to decide at what age is this person mature enough to handle that money on their own without additional management. You may have loved ones in your life who have special needs. Trusts are a great way to manage property for beneficiaries with special needs. That make sure you find someone who is very qualified in creating and drafting special needs trusts. It's not something every estate planning attorney does as a specialization, but it is very beneficial to have a well-drafted special needs trust should you have somebody in your life who has special needs and you're passing on money to them. Also, trusts are really great for blended families. This is a way, for example, where you can leave property to your spouse so that your spouse has enough money for their support, for their maintenance while they're still alive. And then on their death, you direct that whatever's left over is going to your kids from your first marriage, right? So you're deciding ultimately where that money goes. If you leave it outright to your spouse, for example, then it's totally up to them, right? On their death, where they're going to leave the property that they have when they die. So this is a way that a lot of blended families use to make sure the money is going back and taking care of the children that are not of the the current marriage. And it's also a great way if you have any restrictions or conditions that you want to place on the beneficiary being eligible to receive the gift. So you might say, like, you need to, do X. You need to go to college, so I'm going to provide college money for you, and that's what it's going to be used for. Or I don't want you to be engaged in this, bad and unhealthy behavior. So as long as you're choosing to do that, you're not going to get any money out of the trust, right? So a lot of times people will put conditions depending on what they want to have, what strings they want to attach to the money, and trusts are a way that they do that. So again, all of that can be done in a will. You certainly can create trust outside of will. I'm not suggesting that at all, but this is very common when people have wills to be considering adding trust to it as well. All of this you cannot do with intestacy. So in order to have a valid will, it has to be valid under state law. So here in Texas, we have certain requirements. If you have moved from another state to Texas, like I have, you might want to double check your will. I will say my parents, I was born in New Jersey actually, and then moved to Illinois when I was 5. My parents drafted a will like when I was super little, and then my mom passed away. It's been about 15 years now. So they had since moved from Illinois to then they stayed in Texas for a bit, and then they settled in Florida. So by the time my mom passed, she was in Florida, and they're trying to probate this New Jersey will. Luckily, they accepted it, but sometimes because of the different requirements for making a valid will between the states, the will may not be valid in the state that you moved to. So if you've moved from another state and your will is still executed when you were a resident of that other state, make sure you're checking it out to make sure it's still valid here in Texas. Your will is revocable, changeable anytime before you die. So you make the plan that you have today. Don't worry that it's set in stone. You can always make adjustments to it. And as I said, this only applies to your probate assets. So we'll talk a little bit about the difference between probate and non-probate assets. It's not going to cover things like your life insurance and your retirement plans. So your will can't actually direct where those pieces of property go. In Texas, the formalities are pretty basic, but people mess it up a little bit sometimes. And when you mess it up even just a little bit in Texas, it means the will is not valid. So you want to make sure you're getting, again, competent advice on making sure this will is valid. In Texas, we do require a writing. It does have to be signed by the testator, and we require 2 attesting witnesses. Notarization of the will is not a substitute for witnessing. So a lot of people think, oh, I can just get my will notarized. That's not valid in Texas. Some other jurisdictions it is, but not in Texas. So you have to have 2 attesting witnesses, or Texas also allows for an alternative, which is a holographic will, something entirely in your own handwriting. That's tough to do if your will is like 20 pages, right? So I don't necessarily recommend that, but if you have a typewritten will, you do have to make sure it's attested by 2 witnesses. I also strongly recommend, and again, check your wills if you have one, that you have a self-proving affidavit along with the will. Basically, when you go to probate a will, you have to have one of the witnesses come and testify that the will was duly executed. Again, in my mom's example, right, there was a good at least 30 years between when she executed that will and when she died. And one of the witnesses had already passed. The other was actually in an assisted living facility back in New Jersey. So this Florida lawyer had to take her testimony remotely, basically send someone up there to take her deposition so that they could get that will probated in Florida. I'm like, Dad, are you sure this is worth all the effort, right? Like, what does Florida law have that you can't just go by intestacy? But they did that, right? That gets really complicated, right? Trying to locate the witness many years later, they may not be available. So what you can do at the time you execute the will is this thing called a self-proving affidavit. It is notarized, and basically it is the testimony that the witness would say on the stand. And so when you have a self-proving affidavit attached to your will, when the time comes to probate it, your attorney only needs to just offer the will for probate with the self-proving affidavit, and they don't have to call any witnesses. So it saves a whole bunch of time and effort in order to do that. So I've given you an example up here again. This is also in the Texas statutes what the language would say, but just giving you an example of what it might look like. Finally, somebody must have capacity to make a will. You've all heard of the phrase, you must be of sound mind. Have you ever thought about what exactly does that mean, right? Basically, it means that you must be capable of knowing and understanding the nature and extent of your property, the natural objects of your bounty, who are your family members, the disposition that you want to make, and you can put all of these things together in your mind at the same time, Okay, it's actually a lower capacity threshold than the threshold we use to determine if someone is in need of a guardian of their estate. Okay, so people who have a guardian of their estate may still have enough capacity to write their own will. They can ask the court for that. And this is important because as things happen to people, right, and you may be fine now in terms of capacity, but something may happen later on in your life where you then become incapacitated, right? So doing the will now while you are able to is a great thing. And then I'll talk just a little bit about things that you can then do to protect that estate plan in the event you become incapacitated later in life. So there's things that you can also implement now while you have capacity that can help protect against a future incapacitated self. Hopefully that will not happen, but because it may happen, we want to think about planning for that as well. All right, so quickly on probate administration, I think this is somehow like somewhat of a mystery to folks because I think a lot of times people think probate administration, it's so complicated and expensive and oh my goodness, it's like a huge burden. And it can be, I'm not gonna lie, it can be cumbersome and burdensome and expensive, but it doesn't have to be. And so with a will, you can make sure it doesn't have to be cumbersome and expensive unless you just have a contested estate, and then it's gonna be cumbersome and expensive because your family members are fighting over your assets. But assuming everybody gets along, it doesn't have to be cumbersome and burdensome for them. First of all, it only is going to apply to your probate property, not the non-probate property. So again, non-probate property is going to pass by beneficiary designation, or it's going to be a joint tenancy with right of survivorship designation, or some other payable on death designation on accounts. Everything else is generally probate property, so it can be, for example, your home, your car, it could be bank accounts, depending on how those are titled, could be stocks and bonds, depending on how those are titled, your furniture, those kinds of things are generally probate assets. With probate administration, you can do something called independent administration. And independent administration is that thing I mentioned before that is really efficient and time-saving and not very costly in terms of, first of all, court fees are pretty low in Texas in terms of probate administration fees. They're super low. And in terms of your attorney's time, because they aren't going to court very often. They just go to court to prove up the will. They have to file an inventory with the court and get that approved. That doesn't take that much time to do that. And then they also have to give certain notices to creditors and will beneficiaries and file those things with the court. And that's pretty much it. In comparison, a dependent administration would mean that your personal representative has to go and ask the court permission for everything they want to do. They want to pay this creditor, I have to ask the court permission. They want to distribute this asset to a beneficiary, I have to go ask the court permission. So everything they want to do, they have to go ask the court for permission, which means your attorney is going to court every time they want to do something to ask the court for permission for them, right? So that can add up and be expensive. Like I said, it doesn't have to be that way. You can provide for an independent administration in your will. They are still under a fiduciary standard of care to manage your estate assets as a prudent person would. And if they're mismanaging the assets, the beneficiary of the estates can hold them accountable. So they're not, that doesn't alleviate the need for them to still be careful, but it sure does save a whole bunch of time because they're able to just make these decisions themselves as the independent executor about when to pay the claims, how to distribute the assets to the beneficiary, and that just saves a whole bunch of time. And especially when everyone's getting along, this is a great way to do estate administration. But wait, we're kind of putting the cart before the horse because sometimes you don't even need to do that. You don't even need to have a personal representative probate your estate. So the first question I always ask is it even necessary? Sometimes people have so many non-probate assets that their probate estate is basically now their furniture and their car. And there's like really easy ways we can take care of that without ever going to court, without ever probating a will. So we've got that covered, right? So the first question is, do you even need probate? Most of the time, if you've got some assets, you need to change title to things, you're going to have to do something to clear that title. But we can do things with informal probate administration, which means we don't need to have a personal representative. It's an easier way to get that title to the beneficiary of the estate. So if you have go back there. But we need, before we get to the two types I want to mention to you, I also need to talk a little bit about exemption from creditors' claims in probate because we want to make sure that you've got enough assets to pay your creditors if you're going to use either one of these informal probate procedures. So in Texas, we have very generous asset protection and creditor protection in terms of exemption from claims. First of all, we have an exemption for tangible personal property, your car, your furniture, your jewelry, up to $50,000 if you're single, up to $100,000 for a family. Note that this protection only continues to apply after your death if you're survived by a spouse or minor children. So usually you're talking about the $100,000 exemption for it to actually continue past your death. Your home is likewise also exempt from creditor's claim if you're survived by a spouse or minor children, and we don't fix it by value here in Texas, we fix it by acreage. So if you are in an urban area like Fort Worth, you get up to 10 acres exempt. If you're in a rural area, and again, assuming you're a member of the family, then you get up to 200 non-contiguous acres. And again, it has to be your homestead. If you have a second property, you don't get to pick which one the exemption applies to. It's the one that you use as your homestead. This can be applied to. Also, we have an unlimited amount for life insurance in terms of exemption from creditors' claims that extends beyond your death. Unlimited exemption for retirement plans that extends beyond your death from creditors' claims. And also if you're doing certain of the tax qualified college retirement savings for your kids, those plans are also exempt from creditors' claims under Texas law. Okay, so this is great, right? So it's a way to pass these assets on to your family members without worrying about the creditors, except of course for the secured creditor, so that you're still, your mortgage lender is still going to have a claim to your property, your car loan lender is still going to have a claim to your car. But this is more for the unsecured creditors. These assets are protected. But we also have to make sure then there's enough other assets to pay your unsecured creditors if we're going to use informal probate procedures. Otherwise, we're going to go back to having a personal representative manage this process. So with informal probate procedures, there's maybe two types I want to talk about. There's others, but these are the two main ones. One is if you have a will, we can probate that will as a muniment of title only, which means it just serves as evidence of the title transfer from your estate to your beneficiary. So we probate the will, we do a couple of other things. We don't have to have a personal representative to manage all of this. This works really well if, for example, the surviving spouse is the sole beneficiary of all the assets of the couple. They can do this procedure assuming they have enough other assets to pay off the claims of the creditors and get those taken care of. Then this is a really easy way to get that house title transferred only to their name, or the car title transferred only to their name, or the bank accounts transferred only to their name, is to just probate the will as a muniment of title. The other, if you die intestate, is to use what we call a small estate affidavit. You'll notice the dollar amount here is $75,000, and that may be like, wow, that's really low, except when we're computing that $75,000, we're not including any non-probate property, so it doesn't include your life insurance, it doesn't include your retirement plans, doesn't include any bank accounts that you have as joint tenancy with right of survivorship or brokerage accounts. It also doesn't include the value of your homestead, because that's exempt property, right? Notice it doesn't include any exempt property either. And so you can literally be a millionaire and still be able to use a small estate affidavit depending on how your assets are titled and how much of that wealth is tied up in exempt assets like the value of your home. All right, so in Texas, this is really more of a precise determination based on probate non-exempt assets. That has to be less than $75,000. But again, it's a great way for the property to, that just shows that the title to the property is going to the people who are entitled to take under intestacy law. The court basically approves this small estate affidavit, and then they can use that court-approved small estate affidavit to get the title transfer to the land, to the bank accounts, the brokerage accounts, and all of that. Okay. All right, so we've talked a little bit about non-probate transfers. Let me, again, refresh. It's life insurance, retirement plans, can be financial accounts, can be real property, so I'll talk a little bit more about those because it gets a little bit more complicated with respect to financial accounts. So people will sometimes think, oh, I have a joint account. Right? That doesn't necessarily tell me if it's non-probate property, because you can have a joint account, what we call an agency or convenience account, and a lot of parents will do, like older parents will do this with their children. They'll have their child be on the account, so if something should happen to the parent, they can use that money to help pay medical bills or utility bills, things like that. So it's just a convenient way, right, for the child to be able to access the parent's money to pay the bills of the parent for them, but it doesn't provide any benefit at death, meaning that person on the account, the child who's also on the account, doesn't automatically get that bank account when the parent dies. So that's the nature of the third account there, the agency or convenience account. It's the parent's money. It belongs to the parent. Basically, that co-signer or co-account holder has the ability to write some checks on there, but they don't get the property when the parent dies. But a lot of people will call that's my joint account. It's not really joint in terms of survivorship benefits. The first two have survivorship benefits. So joint tenant with right of survivorship, you get the first thing, right? The joint tenant can also sign and write checks on the account while the account owner is alive. However, it also then automatically passes to that joint account owner when the owner dies. So again, in my parent-child example, if the parent then designates their child as joint tenants with right of survivorship, when the parent dies, it will automatically go to that child. Now, what if you had multiple children and that wasn't your intent, right? Because I've had that come up with clients before. We're like, no, like they had 3 kids, but this was the one that was good with the money. That's why they put them on that account, right? It was more for the first thing so they could write checks for the medical expenses and utility bills and things like that. They didn't know they were actually signing it joint tenant with right of survivorship, and now all this money is going to the one child and the other 2 are getting excluded, right? So that may not reflect the intent. So again, that's why it's really important to look back to how your accounts are titled. Make sure they're matching up to what you actually want to have happen. Right, that's one of the things, dangers with multiple party accounts is sometimes financial institutions assume things for you and just give you the account form for X, for one or the other, without really asking you or explaining to you what these different things do. The third account is what we call payable on death, and you can do this with any financial account in Texas, where you, again, in my parent-child example, let's say the parent doesn't want the child to have any access to the account while the parent's alive. That's perfectly fine, right? They can maybe do this payable on death, and basically it just says, when I die, the account goes to my child. And it avoids probate then. It avoids, then it doesn't pass through your will. It wouldn't pass through intestacy. It would just automatically go to that child, just like life insurance, just like your retirement plan beneficiary designations works the same way. And one of the benefits of it is it's an easier way to collect the money, right? Because then the child just needs to go and show the bank the death certificate, fill out a little bit of paperwork, and they get the account, as opposed to having to wait perhaps for a probate administration to get started and for the assets to be distributed from probate administration. Again, it can work in certain situations, but if you have a larger family, sometimes the payable on death is not as effective depending on what you want to have happen. All right, what about real property? In Texas, we also have the ability to do what we call a transfer on death designation with respect to real property, but you have to do a deed that is filed with the real property records. This doesn't give the beneficiary any rights to your real property while you're alive. It's still your home. You still live there. You can revoke it. You can change it. You got to file the revocation, of course, with the deed records. But again, an easy way to just transfer that title at death without having to worry about go through probate administration. You can do a transfer on death deed. And finally, some people have joint tenancy with right of survivorship in real estate, and this is probably pretty common among married couples, where you have a joint tenancy with right of survivorship in your home. If you have that, then that means the home automatically passes to that joint tenant, to your spouse, in my example, when you die. And so again, that title clearance doesn't need to go through probate administration for that to happen, but make sure that that's what you want. You also have, when you're joint tenant with right of survivorship in real estate, that joint tenant has immediate access to the real estate. Okay, so if you have joint tenancy with right of survivorship with your children, for example, guess what? They can move in with you because they have rights to that house too. All right, so this isn't something you want to just like slap on everything with your real property. The other big thing with joint tenancy with real estate that's different than personal property is now your joint tenant in your real estate has the right to partition your home, your real estate, and force a sale. So again, make sure if you're designating something joint tenancy with right of survivorship, it's with somebody you like who belongs there at the moment, and that, again, this is great for married couples, but sometimes with the parent-child relationship, you got to make sure that this is really what you want before you put that designation on there. Usually a transfer on death deed works a little bit better to accomplish the goals for that type of transfer. All right, So, protecting the estate plan. Again, I mentioned a little bit about incapacity, and possibly if you become incapacitated later in life, this could prove troublesome if you haven't done planning ahead of time. A great way to plan for potential future incapacity is to do what we call a durable general power of attorney. There is a statutory form. It's something that you could do on your own, but great to have an attorney help you with it as well. And it really just tells folks, this is the person that if I'm incapacitated, this is the person I want to have access to my financial accounts. They can go and write checks for me. They can go and sell my real estate if they need to. Giving them lots of power over your assets if you're unable to manage, right? Why would you do that? Because the alternative is guardianship. And guardianship is expensive and time-consuming, and again, the guardian has to go to court to ask permission to do all these things with respect to your assets. So you'd never do this, right, with someone you don't absolutely trust, right? So the general power of attorney, what we call durable, I recommend the durable as opposed to what we call a springing. Springing is probably what most of you think about, like, I don't want this to actually be effective unless I'm incapacitated. Okay, that I totally get that. However, when you have what we call a springing power of attorney, then you got to show everybody that you're actually incapacitated, right? Because it doesn't come into effect until you're incapacitated. So if you're going to the bank and your agent under your power of attorney is going to the bank trying to manage your assets, they're going to say, well, show me that the person's incapacitated. So durable instead just takes effect immediately while you still have capacity. I get that. You're like, why would I give my child the right to do this while I'm still capacitated? And I say, if you can't trust them to manage your, like, under this piece of paper while you're still fully capacitated and able to revoke it, then why are you trusting them to do it when you're incapacitated? Like, you've picked the wrong person, right? So be thinking about that when you're picking the people to do this. But this is a great thing to have. A lot of spouses will do this with each other, but then remember, name like some alternatives in this as well, just in case. Another tool that people use for incapacity planning as well as estate planning is the revocable inter vivos trust. One of the things that with this particular trust, I'm going to give you a little model here of what a trust looks like in case people are not familiar, but it basically describes a relationship where the settlor transfers property to someone called the trustee. The trustee manages that property for the benefit of the beneficiaries and then owes fiduciary duties to the beneficiaries to make sure they're not mismanaging things, right? The beneficiaries can hold them accountable. With a revocable inter vivos trust, the settlor is all three of those things initially. Okay, they are the person who transfers the money. They're also managing their own money, and they're at least the initial beneficiary, but there's other people then who take after their death. So why would you do this? Because if the settlor becomes incapacitated and therefore can no longer serve as trustee, your trust instrument just keeps going on without skipping a beat. The next person named as successor trustee can take over and immediately start managing those assets without having to go to court to get a guardian declared, for example, or anything like that. So again, another way to just potentially plan for potential incapacity where someone is always there to help manage your assets should you be unable to do that for yourself, whether it's temporary or permanent. And my next slide just describes what I just said, so I'm going to go quickly through that one. So why might you use this for estate planning as well? Well, it helps provide a unification to your estate plan. Remember I said, like, the will only covers probate property, and then you've got all this non-probate property over here, right? What you can do is if you create a revocable inter vivos trust, it has your disposition, your estate plan, what you want to have happen after your death, and then you can name that trust as the beneficiary on all your beneficiary designations, right? You do what we call like a little pour over will. It's a very short, simple will that says all my estate goes to my trust, right? And that's it. And then everything is held. It basically gets into that trust, and then the trust pushes everything out to the beneficiary. So you're not worried about constantly updating beneficiary designations to make sure they're matching your new estate plan, those kinds of things. Other benefits of the revocable inter vivos trust, we talked a little bit about the lifetime benefits. If you have property in another jurisdiction, so I've had clients with oil and gas interests in Oklahoma, Louisiana, for example. Louisiana requires you to do probate in Louisiana. They don't just take whatever happens here in Texas. You got to start fresh in Louisiana. And for a little oil and gas interest, that can be more expensive than the interests are actually worth, right? So you can transfer those property interests to your trust ahead of time, and then you avoid having to go to multiple states to do probate administration. The trust also just takes, it's always there, right? Again, I said it keeps going without skipping a beat. So upon the settler's death, the trustee, the next trustee takes over, and they can immediately start distributing assets to the beneficiaries of the trust. And that's especially important if there's needs that need to be taken care of. Whereas with probate administration, you got to wait a little bit, right? We got to wait for the, one, we have to file an application for probate. We have to then wait at least 10 days before we can have a hearing, and some court dockets are backed up so much you're waiting like months before you get the initial probate hearing. And then we've got to go to the probate hearing and have the court basically say, yes, this will is admitted to probate, and this person is named as the personal representative, is hereby authorized to serve. And then things can get going. So it can be a bit of a delay with probate administration. The revocable inter vivos trust avoids that. The other thing that I've done a lot of revocable inter vivos trusts for clients who want privacy. I've had celebrities, sports stars, and just generally people who are like, people know me in town, and I don't want them to know all of my business, right? Because with probate administration, your will is public. It's a public document. The inventory that you file with the court listing all your assets is a public document. And some people prefer not to have that out there. So the revocable inter vivos trust, no one knows what it says except the trustee and you and the beneficiaries of the trust. It's not a public document that others are entitled to look at. So it's helpful from that perspective. The one thing, though, I do want to clarify about revocable inter vivos trust is a lot of times people try to sell these to you as, oh my gosh, probate is so complicated and expensive, and this revocable inter vivos trust is going to save you so much money. That is not what this does. It doesn't save you anything on taxes, and it doesn't save you anything on probate administration fees. Because remember that pour over will? You still got to probate that. And in Texas, it doesn't matter how big your estate is, you pay the same amount of court fees. And with an independent administration, you pay generally the same amount of attorney's fees. Okay, so that doesn't save you a whole bunch of money. In fact, it's going to cost you a little bit more money to get the trust created than just to have a will. I will tell you that. But for some people, it's well worth it because of all the other benefits of the revocable inter vivos trust plan. So it really depends on what fits for you. But I want to dissuade that because in some states it really does matter. Like I think California, but I'm pretty sure California works this way. The court fees are actually determined by the amount of assets passing through the probate court. And so yes, this can help save in those types of jurisdictions. Texas is not one of them. Okay, so Texas, the court fee is just a flat court fee. Doesn't matter how much actually goes through the probate court. And then finally, charitable gifts. I just want to mention, and again, just plant a little seed for those who are philanthropically minded, that testamentary charitable gifts are also a great way to support the charities that you love. For purposes of taxes, it's an unlimited charitable deduction, so you don't pay any estate tax on what you're giving to charity. And you can also support not only U.S. charities, but also foreign charities, which is different than the income tax deduction. So if you give a gift during lifetime, those can only go to U.S. charities to qualify for the deduction. With a testamentary gift, again, fully changeable, revocable, so you can always change your mind if things, so one of the things people struggle with when they're wanting to make charitable gifts is, I don't know how much I'm going to need, right? So the great thing about a testamentary gift is you don't have to worry about that question because it's whatever's left over, right? And you can always change your mind, right? So if you have, things change and your relationships change with different organizations, you can always make changes to your plan. With a will, you can do several things. You can do a specific bequest, like I'm leaving my house to this charity, or I'm leaving, this particular stock to this charity. You can do a general bequest, just a sum of money, or you can leave what we call a residuary bequest, which is like the rest of my estate. Okay, any of those can go to charity, and sometimes charities have help in that regard where they can give you some example languages of how to write the bequest in your will in terms of the exact name of the charity, because you want to make sure there's no confusion about their legal name and those kinds of things. So talk with your charity, talk with the charity you want to benefit, see what they have to offer. I also want to explain a little bit of confusion, I think, with charitable gifts, which is the difference between restricted gifts and endowment gifts. A lot of people conflate the two and think they're one and the same. They're actually slightly different. A restricted gift to a charity basically restricts the use of the donation to the specified purpose of the donor. All right. So if you want to benefit a particular charity and you want it to be used, for example, for their building fund, you can make that restriction, and then they can only use it for that building fund. Right? Or you can make an unrestricted gift to charity, which of course they absolutely love, because then they decide it's going to still be consistent with their mission, but they can decide where to best use that money. An endowment gift, on the other hand, is something that goes into a fund, and then the charity is restricted on how much money it can use from that fund each year, and typically limited to the income or a specified percentage of the assets in that fund. And that's all they can use each year. Now, you can have general endowment, meaning, yes, I can only use the income from the fund, but I can use it for any purpose. Or I can have restricted endowment, meaning now I can only use the income and I can only use it for the building fund or for this particular purpose, right? So you can tie the restriction to the endowment as well. But a lot of people think if I'm making an endowment gift, I'm making a restricted gift, and that's not necessarily the case. And a restricted gift, even though it can only be used for a particular purpose, for a building fund, for example, they can spend it all in 1 year. Right, so they can spend it all that year. It doesn't necessarily have to be held into perpetuity. So I mention this because when you're thinking about gifting and you're thinking about the different ways that you want to leave your legacy, these are important things to know at the language that the charities are using, and know exactly how to say, this is what I want to have happen, right? This is the legacy I want to leave behind with the charitable gift I am making. And so you can do all of that, of course, with a will. With a will, you can designate this is the restriction, or I want to leave it as an endowment, and this is like how the endowment should be paid out. So you can design all of that in your will. You can also think about designating a charity as a beneficiary of your IRA. And this is actually a great tax planning tool as well, because when you leave your IRA to an individual, even your spouse, that money comes out to them as taxable income. So if you're in the realm where you're actually paying estate tax, there's the estate tax first that's paid on that, and then that's pretty high right now. That's over $5 million for an individual before you start thinking about an estate tax. So it's pretty high, but it could go back down depending on the law changes. When I first started doing estate planning, the exemption amount was $600,000. So things change rapidly. But assuming you don't have the estate tax to worry about, it's still income taxable to your beneficiary. So when that money comes out of the IRA, the individual getting those distributions is paying income tax on it. So it's not the most tax efficient thing to leave to your beneficiaries. And so if you are charitably minded, you could instead name a charity as the beneficiary of your IRA. Again, you have full access to it while you're alive. You can use the money as you need it, but then whatever's left over can go and satisfy your philanthropic goals. You can still add restrictions on that gift. You can still put an endowment gift in the beneficiary designation, but the benefit to the charities, they get all of it. They don't pay income tax, right? So it's a really great tax efficient way to give to charity, because when you give it to an individual, they're going to get less than the full amount because of the income tax that's charged. So my final recommendation with charities is talk to them, right? If you have a particular charity in mind that you'd like to benefit, like tell them, like, hey, I'm thinking about leaving you as a beneficiary of my will. It is because they can give you guidance on things that are available, right? Certain endowment that they already have established that you might be interested in participating in, or certain restricted funds that they have that you might be able to participate in. They might also have policies where they can't accept certain types of gifts because of the risk management that they're doing for their own organization. And so you want to talk to them about that and know, right, are they going to accept, for example, an oil and gas interest gift? Some charities will, some won't. So you've got to talk to them about what they're able to manage and what their particular gift policies are, but they're there to help you, right? So I just want to encourage you, if you're thinking about that, to include them on the conversation, so that they can make sure, and you can make sure that what you're designating in your will or designating on an IRA beneficiary designation is consistent with their ability to accept the gift that you want to make to them. All right. That is all I have in terms of prepared remarks, but I'm happy to take any questions that folks have. Oh, sorry. Go. Okay, I'm just going to go this way around the room. Okay, yes.
When you have a will, I mean, is it as simple as just making sure the appropriate people know where it is? I mean, it's not recorded or filed.
Yeah, no, that's an absolutely great question. So storage of the will is important, and people knowing that you have a will is really important, right? Because you're not going to be there to tell people where it is when the time comes. So it depends. Like, so sometimes attorneys will offer safekeeping services for your will, which means they basically have a safe deposit box at a bank or somewhere, fireproof, theft proof, all of that good stuff. But you still want to let people know that it's there, right? So that if you're using the attorney services, they know I have a will and this is who you contact to get a copy of it. If you don't use that, I strongly recommend that that you use some sort of safekeeping, protection, so your will doesn't get inadvertently destroyed or lost. So you can have a safe deposit box, for example, for your bank. But when you do that, when you have your own, then you have to have someone else who can access it right after your death, because the banks don't really like to look at you and like you're the next person, and that person's like, I promise you there's a will in there. They're like, you'll show me that you have the ability to access this safe deposit box. And if you don't give them that access, right, if you haven't signed the signature card ahead of time, letting the financial institution know they have access, then they could have problems accessing your will. So you want to make sure that you're, yes, connecting with the person. Most likely, usually you're letting the person that you've named as the executor of your will know these things and making sure that they have the proper access to get to that document after your death, so that things can go smoothly. Yeah, great question. Next, I saw some hands over here. Yes.
See if I can word this properly, but like I'm single with no kids, my parents are elderly. Is there a good place to go to find someone that you would trust to be a trustee or someone when you really don't have a family member to step into that role?
Yeah, so there are all kinds of corporate trustee services out there, and sometimes even when you have people who are, who could do it, they're not necessarily people you'd pick to do it, right? So there are corporate trustee services. Some of them have different minimums as to what they'll accept. So you'll have to just kind of shop around a little bit. But there are plenty of corporate trustee services out there who can serve in that capacity, should you have that need. Yeah, absolutely. Other question?
So if there's a retirement account that passes to an heir, not a beneficiary, through whatever means, probate, etc., do the funds in that account become subject to income tax on transfer or on distribution?
So they changed I have not kept up as much as I should with the retirement beneficiary rules.
The last time you were confident about the answer?
The last time I was confident about the answer was probably a good 15 years ago. Yeah. But I think you have to have a designated beneficiary of the account for them to be able to stretch out the payment. And if you don't have a designated beneficiary of your account, then the money must all be paid out within a certain amount of time after your death. So that's going to accelerate the income tax liability on that.
Would it be redundant for that account to pass in the presence of a beneficiary designated on the account?
I'm not sure I'm following your question. Redundant, so.
If you have a designated beneficiary, is there any point in designating any other means of that account in the absence of distributions to pass?
I would say if you have a particular person that you would want to take in the event your first beneficiary can't take, then yes, absolutely. Put contingent beneficiaries on that account because it's going to allow them to stretch out the distribution. If you don't, though, have anyone in mind, again, this is where you can think about who's ultimately, and I always like to have clients think about it this way, right? If the first set of people that you want to benefit from your estate are not able to, right? Who's kind of your backup? And usually the backup is like, heirs or charity. Those are usually the two camps, right? So again, I'd think about let's put your backup on there as the beneficiary designation. It just may help in terms of their ability to do some income tax stuff later on. Yeah, absolutely. Yes.
Okay, so I have a community property, but my ex-husband, not ex, but we're still working for the divorce. But he could claim the property, but if I rent that property, does it count as a community urgent?
Yes, so in Texas, you are married until you get a divorce through approved by the court. And that is tough for couples who are separated because you're still accumulating community property during this time. So yes, any income earned on the property while you're still married is still considered community property. Now, a lot of couples will be entering into kind of orders and agreements while the divorce is pending. And so I preface all of that with, if there's a particular order or agreement in place in the meantime that covers those things, then I would look to those. But it is important to remember that you continue to be married in Texas until you get a divorce finalized by the court. And I mention that only because sometimes, unfortunately, folks pass while a divorce is pending. And so that's something to keep in mind with estate planning as well, is to make sure your estate planning documents are up to date, especially if you've got a divorce that's taking a long amount of time to get finalized for whatever reason. You might want to just go ahead and update your will in the meantime, so that your soon-to-be ex-spouse is not inadvertently taking, should you die before the divorce is finalized. So those are the questions, yeah.
So, I recently opened the LLC and, I'm a realtor, so I'm planning to buy and, rehab properties. So if I own the property on LLC, so my husband is still, will be the owner, like community?
So it could still be community property, and I would strongly advise you to talk with your family lawyer about all of this, just to make sure if you're setting things up now, that you're setting things up in an appropriate way. And again, there may be orders or agreements that the court have already approved that helps protect you. But I think your family lawyer will be able to help with your specific situation and let you know kind of what's going on with your assets.
But if I own the property outside the state, it doesn't count as community property?
In Texas, yes, it could. It could count as, yeah, I mean, in terms of well, first of all, the ability of the court to divide it between the assets, because you are, if you're using community property funds to purchase assets outside of the state, then we can get jurisdiction over that here in Texas. Yeah. Yeah. Mm-hmm.
Back to your Louisiana gas example. Is probate being driven by where your will is developed within that state, or is it being driven by where your property is?
Yeah, no, that's a great question. So if you have property in multiple jurisdictions, primarily probate and the laws of probate are the laws of the state where you're a resident or you're domiciled at the time of your death. So if you're a Texas resident, usually Texas probate law is going to apply to your assets, to your will. However, there is an exception for real property. And real property, it's the law where the real property interest is located. That's going to govern the probate of that particular piece of property. So if you do have real property in other jurisdictions, a vacation home in Colorado, for example, or or oil and gas interest in Oklahoma, Louisiana, the laws of those particular jurisdictions are going to govern how those interests pass. If you have a will that you've made here in Texas, it's quite possible it still can be probated in Louisiana or Colorado or Oklahoma. Sometimes, if you have a probate going on here in Texas, all you have to do is let those jurisdictions know that, and they don't require a new probate be started. They'll just kind of take whatever Texas is doing. It's just, in my experience, Louisiana was not one of those, and so we had to start fresh in Louisiana.
If, let's say your real wealth, be it a real estate or mining interest or a business, whatever it might be, is located outside of Texas, locally, would that affect how you design your will in terms of trying to manage probate?
Yeah, so if you have a large amount of, and again, this is just to clarify, real property wealth, because if you have like personal property, let's say you have a safe deposit box in New York with a bunch of gold bars or something like that, that's still going to be governed by Texas law if you're a Texas resident. So if you have a significant amount of real property wealth outside the state of Texas, then again, this may be something where you're considering that revocable inter vivos trust. Instead of trying to design a will around multiple jurisdictions, you're instead using a trust instrument that can cover all of those things and unify everything together. So it's just expressing what you want to have happen without worrying about having to deal with the intricacies of the different laws of those jurisdictions. So, yes.
What are you saying after revocable, irrevocable?
Oh, inter vivos. It just means lifetime. Revocable inter vivos trust. Inter vivos trust. Mm-hmm. Yes. Yeah, so in Texas, so this is where our venue lies. In typically for probate administration, the proper venue for probate is the venue, the county where the decedent lived at the time of their death. Because remember, our concern is not so much for the convenience of the personal representative or the executor. Our concern is for proper notice to the potential creditors of the decedent's estate. So more likely, if we're putting notice out we have to do like public notice. And if we're doing a publication that's local to the county where the probate's happening, we're more likely to reach potential creditors if it's the county where the decedent is alive now, or was living when they died. Now, if we have a situation, this really affects ancillary probate. So, for example, let's go back to my New Mexico example, and the decedent was not a resident of Texas, right? So then what county do we go to? Typically, it's the county where the real property is located, is where we would do the probate. Yes?
If a property has been declared undivided interest in ownership, how do you decide how much is your ownership of it?
Great question. So if you have an undivided interest in property, how much is yours? You probably just need to go back through the deed records and see what was the grant of interest. And that will tell you how much it is. A lot of times, this affects oil and gas interests, so the companies paying out your royalties have good records of what is your certain percentage interest in the property, but it can apply to any type of real property, right, or even personal property. And so if you're not quite sure how much is my interest, you go back to the original granting interest to see what it is. And those are available through the deed records, and the deed record search for most counties is generally available online. If you actually want to get the records from the deed from the county, sometimes the counties charge a small fee to get the copy of the record. But a lot of, like most of the bigger counties, that stuff is all available online, and you can get at least see initially what some of the stuff says through an online search that's free without having to go down to the county records office or having to pay a fee to see what's out there. Yes?
If both spouses are named on a mortgage document, does each spouse get 50% interest in the property when the mortgage is paid off?
So when the mortgage is paid off and both spouses are named on the mortgage interest, it really depends on what is on the deed to the home. And usually you don't have a mortgage. Well, I mean, you could have a mortgage with two people, I guess. I'm trying to think. Usually if the mortgage is in both people's names, that means the deed is in both people's names. Yeah, and I would say again, it depends on whether it's community property or separate property. Yeah, and so community property, again, is community property until the marriage dissolves, meaning it's presumptively 50-50, but for those who go through a divorce, the court doesn't have to divide it evenly, right? They're not bound by that. So community property, when a couple's marriage is dissolved by divorce, is divided by the court in a just and equitable manner. However, so they could give the entire thing to one spouse, for example, or 80%. When the marriage dissolves by death, then the community is split equally. Another question? Yes.
This is the last question. I mean, we were respectful of Terry's time.
Okay.
And like that. So I think there was one back here, maybe? Did she answer your question?
I did have one, but.
Yeah, you were the last hand I saw.
Okay, so the difference between separate and community property, I understand if it, the interest and things like that go back, if you had a gift and they go back into community. But if you had a gift, monetary, and then, say gold bars were, purchased and the value went up, is that then, because it's converted into another entity, is that then community, or does it retain it separate?
So with separate property, the increase in value of separate property remains separate. Okay, so your gain, it's just income off of separate property is community property. And you can take, if you had $50,000 of separate property when you got married and now you've purchased Tesla stock and Tesla has increased, all of that can continue to be your separate property as long as you can adequately trace those funds. So the burden is on the spouse claiming the separate property nature to be able to adequately trace all of that. And if they can't, then the community property presumption is going to apply. Great. Well, I want to thank you all for your time and attention and really appreciate being able to talk with you. Thank you.